Alex here, and we are live. I am here with Wendy Hernandez from Command the Courtroom. Hi, Wendy.
Hi, Alex. How are
I'm
you?
really good. One of the constant questions that I get from my viewers, by the way, we've got the chat open, so if anyone can't hear me or Wendy, let me know. I'm gonna make sure that your sound is connected really quickly. Just a second.
Okay.
Let's see here. Could you say something, Wendy? Oh, okay,
Yes,
it's
something.
perfect. It's been fine. I just wanted to make sure because I've had so much trouble ever since they transitioned away from Google Hangouts. So
Oh, yeah.
one of the questions that I get all the time is, do you have any tools? Can you help me with this type of advice? And as you know, and I think most of my viewers know, I'm not an attorney, so I can't give legal advice, and I really
Mhm.
haven't put any tools together. So usually we just kind of go into a general discussion, but this time I got a huge list of resources from Wendy that we can go through and that she can sort of explain what the purpose of each one of them is. And I guess before we start going into all of those tools, you could go ahead and let the viewers know sort of where you practice and all those little
Mhm.
details. So go ahead.
Yep, sure. So my name is Wendy Hernandez, and thanks for joining me, and thanks to Alex for inviting me. So I'm an attorney in Arizona. I've been practicing family law for 20 years now, um, and I do everything from divorce to child custody to child support cases and everything in between. And I want to let you all know that although I'm a practicing attorney, I'm only licensed in Arizona. So I'm not your attorney. We don't have a attorney-client relationship. This is for educational purposes only. I know there's people that are all over the country watching, maybe even from other places in the world. So you always have to check your local rules, check the laws in your state and jurisdiction. And if possible, consult with an attorney if you're in a state other than Arizona or Nevada, because I can only talk about Arizona. So I have a bunch of resources. My passion is helping people who either don't want to hire attorneys or can't afford to hire attorneys. And I teach them how to navigate the courtroom and understand child custody laws. So that's what I love doing in my quote spare time.
So in Nevada, that's actually a pretty big problem. People who cannot afford attorneys. Apparently, the precise percentage amount is 61% of cases here have an unrepresented party. Is it as bad in Arizona or worse?
I've heard that it's more like 86% of people in Arizona. I think that statistic is a few years old. I don't know if there's been any updated studies or research, but I believe it's the number of pro pers is pretty high in family law cases.
So I was going to ask a couple of questions that I had, but I think one of the things that we should probably lead off with is the 21-day challenge. So
Yeah.
my viewers, I just want to let you guys know that I'm trying out all these new fancy things with OBS, and one of them is I can actually run a video clip. So I'm going to go ahead and run that clip of Wendy's intro clip for the 21-day challenge, and then as that completes, we'll switch back and we'll talk a little bit more about that.
Cool.
Hi there, it's Wendy. I'm so happy that you joined the 21-day child
Okay,
custody
but I can't
challenge
I
and
can't see you.
welcome.
Is that normal?
So each day
Yeah.
you're going to get
Okay.
released that day's challenge. And
Okay.
each day you're going to get a thought prompt, something for you to think about, something for you to consider. And I'm going to issue to you a turbo
Okay.
challenge for the day. And that is something where you take action. You actually do something to move you closer to your goal in your child custody case. It's not going to take a lot of time to consume each day's content, which includes a video. Some videos are longer than others. But what takes the time is you doing your homework, you doing the work. I'm giving you the tools that you need to get you pointed into the right direction, but you have to do the work. Now, I want to say with the first several lessons, you're going to feel like, okay, are you kidding me? You're talking to me about file organization or getting a calendar. But I want you to know these are the basics. You'll hear me say that these are the foundation. These are the important pieces to your case, because if something's not in place, if you don't calendar an important deadline, or you can't find what you're looking for, your case is going to crumble. It's going to fall apart on you. And these are the things that I do in every single one of my cases to set myself up for success. I want to set you up for success. So come with me as we do these basics. Do all of the exercises, and maybe you don't have time to do them on the days that the challenges are released to you, well, then catch up on the weekend. There are exercises about envisioning what you want life to look like with your children and ripping out pages or posting pictures, putting pictures in your file. This is important stuff, you guys, because you have to know what you want. I ask each and every one of my clients when they come to me and ask me to help, I ask them, what is it that you want out of this case? And I get them to say it to me, because they're not only going to have to say it to me, they're going to have to say it to the judge. All of this stuff is important. And I try to break it down into bite-sized, actionable pieces, taking you step by step through the process. Now, you know, taking this challenge, we're not going to get all the way there in terms of preparing for trial. I have other resources available for that. And, you know, I'm thinking of doing some other things to help you in the courtroom. But what this challenge is about is helping you gather your evidence, get your mind in the right place about what you want to show to the judge, to convince the judge that the judge should give you what you're asking for. So if you have any questions, drop me an email, drop a comment in the comments. If you haven't joined the Facebook group already, click the link and go to the Facebook group. Remember that you have to answer the 3 questions in order to be accepted into the Facebook group. I hope that there's going to be a lot of interaction and support in the group. I want to build a community of people who help each other, a community of people who are positive, and a community of people who encourages and cheers their fellow community members on. I want you guys to get what you want. I want you to be successful. I want to help you. I'm here for you. Have fun with the challenge. It's not a game. This is not a fun process, but, you know, make the best of it. Have a positive mindset. So anyways, I'm going to stop talking now and let you get to the challenge. And I will see you there, and I will see you in the Facebook group.
You're done. Okay, we're back. The video is over. I hope you guys loved it. Looks like I've got a image up on the screen. Yes, you guys can definitely see it. It's your 21-day child custody challenge image is up, and I think this is good. Good opportunity for you to lead off now that your video's over. So go ahead.
Well, so one thing that I talk a lot about in my materials and in the work I do is that it's all about the children. People ask me all the time, is it a mother's right state, a father's right state? And I like to refocus direction and say, it really should be a children's rights state or jurisdiction, wherever you are, because this is always about the best interests of the children. So when you are presenting your case to the judge, you should really be focused on what is best for the children. And wherever you're located, there should be a series of laws, a series of statutes that tells you what factors the judge is going to be looking at in your case. These are commonly referred to as the best interest factors. And whatever those factors are, you better be darn sure that you address them in your case. If they apply, then you have to show the judge how they apply, provide your evidence, provide your witnesses, provide your testimony. If a best interest factor doesn't apply, then tell the judge it doesn't apply. But that's what a good judge is going to want to hear about. The best interest factors.
So I just actually switched over to your best interest factors worksheet. I'm going to scroll down a little bit. I don't know if it helps you, but how do you use this sheet? How exactly do you apply it?
Well, and I don't have the sheet right in front of me because it's not showing up on my computer, but I will tell you, so I have a few different courses, and I have a best interest checklist, which anybody can get for free. If you go to commandthecourtroom.com, you can sign up for the best interest checklist. And so what I did with that checklist is I gathered as many different best interest factors from as many different jurisdictions as I could. And so there are a ton of best interest factors, and under each of the best interest factors, I have potential questions that a judge might have around that best interest factor. So I developed the worksheet to help the individual who's preparing the case to evaluate each best interest factor, if it applies, and then try to understand what sort of evidence might help support that best interest factor. Because I feel like sometimes there is a gap or a disconnection between, this best interest factor applies and this is how I prove it. I think sometimes people don't understand you need to gather the evidence, then present the evidence to show how it applies. Does that make sense?
It absolutely does. I actually paused at that point. I was going to ask you more about it. You explained a lot, but I have the same problem on my end. A lot of people do understand the best interest factors after I direct them to it, but then they don't realize that they have to prove it. And I notice here you emphasize tracking down witnesses and also not only paying attention to the fact that they need evidence, but whether or not the evidence is in their custody. Do you also help people understand how to retrieve evidence that they don't have but they know exists?
Yes, I do. So, like I said, I have a few other programs, or a few programs, and this is the thing. Like law school was 3 years of hard work. It was 3 years of hard time in South Bend, Indiana. That's what I say, because it was hard. That was probably some of the most challenging times in my life. Like I didn't breeze through law school at all. So what I'm trying to help people do is really cut through the chase. Nobody's going to be a lawyer after they do my programs. I mean, I'm not saying that they're going to be a lawyer, but they're going to be steps ahead of where they would be without getting this information. So I have, some one program focuses on the best interest factors. That's build your best custody case. Another program focuses on trial skills and what you do in the months building up to trial, and that is called the discovery process. And that, Alex, is where you can get information about the other side's case by doing things like propounding discovery requests, also known as interrogatories or requests for production, requests for admission, or subpoenaing documents. So, yes, in one of the programs, I do help people figure out how they can get information. I let them know what tools exist.
One of the things that I notice my viewers struggle with on Discovery is they use the Discovery tools to just kind of continue the litigation itself. So they have this list of accusations and they just ask the same questions and they get the same expected answers. I don't know about you, but do you think it's more constructive to use the discovery tools to sort of narrow down what types of issues are going to be up in the air, what types of witnesses you're even going to need? I don't know, but that's sort of the strategy that I took in my case.
And it does depend. And I certainly experienced that, especially when attorneys are on the other side. Um, in Arizona, everybody has an affirmative duty of disclosure. So there's two big D's in the law: disclosure and discovery. And I don't know how it is in Nevada, but here we have a duty to disclose anything that might be relevant in a case to the other side. Now, that often doesn't happen. So then that leaves the other side to try to discover this information using the discovery tools. And I do also agree with you, yes, that if you narrow your requests to address the issues in dispute, then it probably is more effective than just like throwing a bunch of spaghetti at the wall. Uh, because it does prolong things and it costs money,
Yeah.
it's stressful, and it can really anger the judge too.
I don't know. I think you don't have the same problem with regards to hearsay. I'm not sure. We could talk about that in a second. But in Nevada, when you have like an attendance sheet from a school, one of the biggest pains is having to get somebody in there to authenticate it. And like I try to
Mhm.
tell my viewers, that's one of the great things to actually throw into like an interrogatory or a request for admission, because oftentimes the other parent isn't going to want to say, yeah, that sheet's not authentic, because they're going to
Mhm.
embarrass themselves if somebody comes in and not only did they authenticate it, but it did end up being 14 times absent or something. I
Right.
think that, I mean, I'm not sure because I know you guys have some rules that are waived. Is it the rules of evidence or?
Yeah, yeah, it's crazy here, and I'm like thrilled about it because like the evidence was not my favorite topic in law school, and it's not my favorite thing to deal with now. But yeah, in family law cases in Arizona, we don't have to abide by the rules of evidence unless somebody specifically invokes it, or specifically requests that those rules be invoked.
Mhm.
So if anything pertains to the best interest of a child, judge is pretty much going to listen to what it has to say
Mhm.
or hear what that person has to say or look at it. It doesn't mean that the judge is going to say, yeah, I accept this 100% as fact. The judge is going to give it the weight that the judge thinks it deserves, depending on whatever that document or thing is. But, the judge will still look at it.
While we were talking about that, I pulled up your objection cheat sheet because it does kind of tie into that. Is there anything you want to let us know about this cheat sheet? I'm going to scroll down while you talk about it a little bit.
Yeah, sure. So I created that little cheat sheet because, again, objections and evidence are very closely related. And these are often very stressful things for people when they're in the middle of the trial, either objecting to evidence that they don't want admitted or to testimony that they don't want admitted, or being objected to, because then you have to think on your feet and explain to the judge why your evidence should be admitted. So I created the objection cheat sheet as something that people could just, print out, 3-hole punch, put in the front of their binder, and just be prepared with their critical pieces of evidence that they want admitted and why they think this information is relevant. Because if an objection does arise, they're going to be more prepared than they would if they just hadn't thought about it. So, and on the other side of the objection cheat sheet are the most commonly used objections. Now, I don't explain what they are. That was a semester of law school. but I have the objections. And what I tell people about objections is, some, like with me, even me doing this 20 plus years, like sometimes I know that a question doesn't sound right, or or a piece of evidence maybe just doesn't feel right, and I feel like I should be objecting, but I'm scrambling to pull out of the air the objection. So if I have the cheat sheet, maybe I can quickly look at it and say, okay, hearsay, this or that. And once in a while, if I get it wrong, a judge may say, well, Ms. Hernandez, that was the wrong basis for the objection, but it is objectionable, and this is the correct basis, and the judge will sustain the objection. So the thing is if you object and you do it respectfully, you may win on the objection and it may be sustained. And when I say respectfully, the way that I was taught to do objections is, you don't scream and jump up and down like a crazy person like they do on TV. But if you want to object, then you stand up. That's what my professors taught me, because when you stand up, it often signals to the judge that you have something to say, but you're not interrupting. You wait till the question is stated by the other attorney or party, and before the answer is given, then you firmly state, objection, Your Honor, and then you state the basis. You don't have to yell, you just state it firmly. And the judge, go ahead.
Oh, sorry. I was going to say one of the most common mistakes that ends up happening, at least with my, the Proper Person channel, is people object when the witness testifying is lying. At least they perceive the person to be lying. And is that one of the things you really have to emphasize when you're teaching, proper person litigation? This is an opportunity for you to say you're nodding a lot.
That's correct. Yes, that is correct. I mean, and what's funny is so many people come to me and they say, but they're lying, like it's perjury. Aren't they going to jail? And, I think like before I went to law school, I thought that too. And lying is really bad, but it happens every day in court. It happens all the time. It happens in almost every single case I have. And I think judges see it all the time. And I'm not saying that it's a good thing, but judges are used to it. But the proper way to combat when somebody is lying is on cross-examination, when you are impeaching them. And there is a right way to impeach and a wrong way to impeach. And again, like the right way is not by screaming at somebody and being verbally abusive. I mean, there's a process to impeachment, but that's when you show that they're lying, not in objecting. So that's a really good point.
Here's two questions that I have. I'm going to tie them together. And I sincerely do not know this answer, and I need to learn it because I get it a lot. I do not understand how the business records and public records exception to hearsay works, and I need to get that.
Oh, so this is your question,
I
Alex?
sincerely wish I knew how that worked. I know that's a thing.
It is a thing. It is a thing. Well, I can't say that I can tell you how it works without looking it up, but there are certain requirements, and I'm sure if you just Google it, that the records have to be kept in the ordinary course of business. And I can't remember, there are several prongs related to that business record exception. And if you ask these questions, that they're kept in the regular course of business, I don't want to look it up right now, but you have to ask those questions to establish the 4 prongs, and then it should be admissible.
Okay.
So that probably doesn't help you very much. I'm sorry.
It kind of does. So that gets around having to have a witness testify. Is that what I'm?
Well, let me tell you this. So often when I send out subpoenas, because I do this, in the course of discovery, I send out an affidavit of the custodian of records. And have you ever heard of this
I have
before?
heard of that.
Yeah.
That's helpful. Keep going.
Yeah. Okay. So we send out with every subpoena request an affidavit, and it basically it's a fill in the blanks thing.
Mhm.
And when we get records responsive to a subpoena, then the custodian of record has to complete that affidavit saying, I'm the custodian of records and these are true and correct copies of the records, blah, blah, blah. And it's signed in front of a notary.
Mhm.
So when you have that affidavit of custodian of records, then that makes the records admissible
Perfect.
without having, yeah, that's what I do to get around that. Of course, like I don't have to deal with it much because of the hearsay rules in Arizona,
Okay. Okay, that's good.
but but that's what I
Yeah,
do.
that's a big thing here because those rules are all in place and the pro se litigants trip over them all the time. The rules of evidence do apply and I guess it's not so, I mean, I guess I'm going to be comparative here, but I guess when these objections aren't being made appropriately in front of the judge, it's not as bad as if you're in front of a jury because it could taint the jury so badly to hear the responses to an objectionable question. I'm not
True.
sure if I just thought of that just now. I'm gonna,
Yeah.
so go ahead.
No, and I was going to say the thing is about objections. I guess my philosophy is if you feel that something's objectionable, you should, well, you know this, Alex, like you should try and find some ground for it, because if you don't object, then you waive that objection. And potentially, if you make an objection and the objection is um, overruled, potentially that could be an issue on appeal. But
Yeah, I mean, it's a lot of times here, it usually takes quite a few. Because there will be sometimes occasions where the appellate courts will say, yeah, that shouldn't have been overruled or sustained. But if it's just one or two things, oftentimes they just say it's harmless. But if
yeah,
it's a whole
okay.
slew of them, or if there's a jury involved, it seems that they're more sensitive to that kind of mistake because I guess they expect the judges can set aside inappropriate things
Yeah.
more easily. So I was going to switch to my question now. We had some videos come up in the My Docket series, and a lot of people noticed, and even I noticed in hindsight, it's crazy how you forget this stuff 10 years back. It's like I'm watching somebody else in court, but it's me. And one of the things that came up was an in-camera review of my ex's mental health records. And one of the questions people were asking about, and I can pull up your document in a moment, but one of the questions people ask me is how did I not get those mental health records despite the fact that the court said that they were relevant? And I don't know if that's right or wrong. I'm going to go ahead and let you take over on that.
Okay, well, so one of the best interest factors is the mental, emotional, and physical health of all involved parties. And it's not it's not of just the parties, of everybody that's involved. So if you have a child who has a mental health issue or a physical issue, that's definitely relevant to the court's decision making or custody or parenting time findings. And if there are mental health records or just regular medical records that exist, then the judge needs to see those. But because of rules, I can't just go down to the doctor's office and get the records, or I can't just email the doctor's office and get records. There's certain rules that are in place, and we have to get signed authorizations. They're called HIPAA authorizations to obtain those records. I've never had a problem in Arizona. Well, I've only had one judge, or maybe one or two judges, say that I couldn't have the records. In all other cases, the judge forces the person to sign the HIPAA release. In a case that recently that I had, the judge said, listen, Ms. Hernandez is going to ask you to sign the HIPAA release so she can get these mental health records. And I'm not going to force you to sign it, but if you don't sign it, then it's going to be a negative inference against you at trial. And what that means is that I am going to assume that the fact that you didn't sign it means that those records would have revealed something detrimental to your case. In another situation I was explaining to Alex right before we came on air. One of the parties was in the special forces. So allegedly, at least he said, that there was classified information in his medical records, like protected by the federal government. So for that reason, the judge said, okay, I'm not going to order that he give you the records. I'm going to look at them in camera and then, make decisions based on that. But generally speaking, because mental, emotional, and physical health is at issue, judges say those records need to be produced by, the party having the medical records, or HIPAA releases need to be signed so you can get the records, or so my client can.
Oh, so the first thing that I noticed is the fact that it took like state secrets for an in-camera review to occur in your
Mm-hmm.
situation. And I think that's
Mm-hmm.
one of the things that I warn people about with self-representation bias in Nevada is oftentimes where the judges have discretion is where this bias bleeds through. And it's
Mm-hmm.
just, it doesn't seem normal at all for, in my case, for it to be reviewed in camera.
I agree.
It's anyone that I talked to is really surprised that I wasn't able to review the documents. Later on, I
Mm-hmm.
did some research and I discovered that apparently an in-camera review is not to make a ruling. It's actually to determine if, I don't know if you know if this is true or not. I'm not even 100% sure, but from what I have looked at, it's to determine if they're relevant. And once relevant, they're
Right.
to be turned over. That
Yeah.
did not happen in my case. And I don't know if I'm kind of surprised that they do the HIPAA release thing. I think that's nice.
Mm-hmm.
It probably makes it a lot easier. But we have some
Yeah.
case law in Nevada where if you issue a subpoena to like a hospital and they don't turn them over, the hospital in the case that I'm thinking of was actually fined. The
Wow.
hospital cited HIPAA, and the Supreme Court said that doesn't overpower a subpoena.
Wow, that's fast. That's interesting. I need to check and see if we have a case like that here, because I mean, our general practice is just a HIPAA release, but that is
I
interesting.
like actually when the family courts do stuff like that because I don't think that these third parties should be forced to have to deal with our domestic issues,
That's
and
true.
I wish more judges would do stuff like that and force the parties to do all the work themselves. We have
Hmm.
weird cases here sometimes where the parties will have teachers making second copies of homework to give to the two parents, anything like,
Come on.
I don't know, have you seen that happen in Arizona?
Um, I have not, Alex.
It's
No, I haven't seen
so
that.
inappropriate to turn the
Yeah.
high to put the high conflict burden on doctors and nurses and teachers. It's like find out
Yeah.
who is being a knucklehead and to
I know.
because
I
and
know.
that's embarrassing to the child or the children. Yeah, that happens here a little bit.
Oh,
The other
wow.
question I have that I know zero about is people ask me, how does exclusive possession of the community residence work? And I have
Hmm.
no answers because that didn't come up in my case at all.
Hmm. So I get this question a lot, and I can only speak for my experience in Arizona. But I had a client come in this week, or a potential client, and say, "Hey, I think that me and my girlfriend are going to break up, and if I leave the house, does that mean that I'm giving up rights to the kids, and am I abandoning them?" And the answer is no. In Arizona, the answer is no. Just because you leave doesn't mean that you're giving up rights to the kids. Is that the question that you're asking, Alex?
That's actually a separate question that I get too. I want
Okay.
to talk about that one in a second. But the one I'm
Okay.
asking about is there'll be two people who live in the same home, and the question is who is going to be forced to move out by the court?
Got it. Okay. Got it. So, and that does, yes, that does come up. Um, it comes up in divorce cases, mostly for me. Um, And so sometimes the environment is so toxic that one party or the other makes a request for temporary orders that he or she be granted exclusive use and possession of the home. So, there's no one answer. Like, there's never one answer for any of this. But, I think a judge looks at, who is or who has historically been the primary caretaker, and should the children remain with that person, and who's being asked to be forced out? Is it, the primary caretaker asking that the other person be put out, or is the other person asking the primary caretaker to put the other person? Is the person who's not the primary caretaker asking that the primary caretaker be taken out? But I think that overall, a judge is going to look at what is less disruptive for the kids. Um, so it's a case by case thing. One thing that I have had a couple of judges order is that the kids stay in the home and that the parties move in and out of the home depending on who has parenting time. I don't know if you've ever
Right.
seen or heard of
Yeah, we
that.
call it nesting, but it's rare.
Yes.
It's so
Yeah.
rare. So
Yeah.
that's one of the worries I had. I guess you kind of answered my question. It sounds to me like there really isn't any sort of legal standard in place. But I mean, that's not necessarily bad, but it sounds like the judge really just kind of, it's like purely discretional. It's wide open. And the
Totally.
reason I get those questions from a lot of unrepresented people is because oftentimes it feels to us like all we have is the law, because we just don't
Yeah.
have any like you have relationships with other attorneys and with the judiciary. Oftentimes judges have gone to school with lawyers, or sometimes it's not that connected. Sometimes it's just lawyers who've gone to school with other lawyers, but there's some relationship there, and as non-attorneys we just don't have it at all. So when things are
Yeah.
wide open, it's usually, it feels like it's not going to go well for us.
I know. Well, it is scary, and there is no one answer on that. And I would say on that, the issue of exclusive possession, I think another factor is who can pay for the home.
Yeah.
Who is financially capable of maintaining the mortgage on it. And that may play into it as well. If you have the primary caretaker who wants to stay in the home, but they can't pay for the mortgage, and so then the parent who's not the primary caretaker now has to pay for the mortgage and pay for an apartment and pay child support. I don't know, that may tip the scales in another direction.
So I'm going to shift gears towards what you originally thought the question was, because I get this a lot. Well, it's actually a really big one, because what will
Yeah.
happen, at least in my channel, is people complain about domestic violence or threats in the home, but the
Mhm.
victim or targeted person is worried that they aren't doing anything wrong, so they don't feel like they should have to leave because they aren't the
Mhm.
violent one. But what
Mhm.
I told them is you have really no choice, because the court isn't going to get involved quickly enough. And every
Mhm.
moment that you stay, either you are going to be attacked physically or you're going to be set up if you're dealing with a liar, because sometimes there's that
Yeah.
part too.
Agreed. I agree. I agree 100%. And I deal with this issue often too. And again, it always goes back to the kids. And if a person is in a situation that is toxic and violent, I don't think any judge in their right mind would hold it against that person if they made the decision to leave to protect their own safety and health. And also, by doing that, protecting the safety and the health of the children, because it's not good for the children to observe this. Whether the children, sorry about that, whether the children are the ones who are actually being physically harmed or not, it's still harming them. It's hurtful to them, and they should not be seeing that. So I agree with you, Alex. Either the person who's the victim is going to continue to be there and get hurt and hurt the kids, or they're going to leave.
Yeah.
um, but they have to make the right call in that situation.
Yeah, I stress to my viewers the importance of just getting out of there.
Mhm.
And a lot of times it ends up being used against them later on. And I guess I call these double binds, where if
Mhm.
you do one thing, it's going to be used against you. If you don't do that, they're still going to use it against you. I don't know. How do you deal with trying to get people to not worry so much about how they're going to be perceived and worry more about presenting their case?
Oh, that's an interesting question. Um, well,
See, with
about how they're going. I mean, to me, yeah, it's kind of one and the same for me. Go ahead, but you were going to say something.
for mine, it's as if they are trying. Because I think for you, it's your instinct to do this, but mine don't seem to understand that they need to put on a presentation, and so all
Mhm.
they're concerned about is trying to relate to the judge. And
Mhm.
I try to shift them from trying to connect with this person who's on the bench to trying to see
Mhm.
themselves as putting on a presentation, almost like a
Got it.
PowerPoint, or I don't know.
Yep. Yes. Okay. I get what you're saying. And so this is the thing. I used to be a criminal defense attorney. I was a prosecutor early in my career for 3 years, and then I left the prosecutor's office and became a defense attorney, criminal defense attorney. And so all of my cases as a defense attorney were tried to juries. And when you're trying cases to juries, I think it is important to try to connect with the fact finder, which is the jury. And the people on the jury, for the most part, are non-lawyers. I never selected a lawyer for my jury. to sit on any jury panel. And I've never been selected when I've been on jury duty, and I like to have priests and I'd like to have school teachers because I felt like I could connect with them as a defense attorney and appeal to their emotions. I think that judges are a little bit of a different breed as our lawyers. And that's the reason I never want lawyers on a jury, because we are trained to follow the law and to read the law and to dissect the law, as are engineers, who I also never wanted on juries. And so I think lawyers and judges and engineers, are probably less swayed by emotional arguments. So when you talk to your judge, you do have to talk to your judge using the law, applying the facts of your case to the law and arguing it that way, because that's, the judge has to follow the law. And if the judge doesn't, then the judge, as Alex can attest to, will get smacked down, right?
Yes, they do. When you just brought up the jury again, and it reminded me about your 21-day challenge. Now, I don't think that this is something that you cover, because I think that's a 21-day challenge for a custody case. Does it also
Yeah.
include dealing with jury stuff in there?
No, it does not.
And it
doesn't.
wouldn't need to, I guess. Do you think it's weird that some states have jury trials in these custody cases, like Texas?
I think it's interesting. It is weird. I mean, I think that would be kind of fun,
Yeah.
but it would also be kind of scary too. But it's always scary, and what's funny is I always tell my clients that going to trial is like taking your life and throwing it on the craps table in Las Vegas. That's how I feel.
Yeah.
Because, you may think that you're presenting things a certain way and that the judge should rule in your favor, but your judge, although they're not supposed to, they have opinions, personal life experiences and emotions, because they're human, and you just don't know where they're coming at your case from.
Mm-hmm.
And, you may say something that strikes them wrong. They may have had a mother who was a victim of domestic violence, or they may have had a child who was killed by somebody driving under the influence. You just don't know what's going to trigger a judge. A judge just may wake up on the wrong side of the bed, and it could be very bad for your case. So I tell people that, you just have to know that when you walk into your trial, you just don't know what's going to happen. You can have the best case possible, present an excellent case, and it not go your way.
I have another really good one. You'll just, when you talk, stuff pops into my head, and one of them is, I've told people to not get too, they don't like to hear this, but I tell them, don't get too obsessed with trying to prove your ex is a liar, because sometimes you just aren't going to make any headway there, and you might have what I used to call it an alternate truth, but that sounded cheesy to people. It's like, oh, you mean you're supposed to lie back? No. What I mean is, you may be trying to win your case on 4 or 5 different assertions, each of which has to be proven to be true. And I try to tell them, if you can't get through on this one because it's you're getting lies, try to shift to the other one. And
Yeah.
I don't know if that's one of the things that you have to deal with pro se litigants, but with me, they get stuck on their ex lying and they can't get off and move on to the other parts of their case where they could actually win by showing these other things. I don't know.
I agree with you 100%. And, a lot of times people come to me and they say, well, my ex did this, and like this should win the case. And it's not like that for any case. And I don't care how, unless it's like your ex committed murder or put you in the hospital or stabbed you or something, because a judge is going to look at all of the best interest factors and take them into consideration. So you may have one that really weighs heavily in your favor, but then one where you really screwed up and that weighs against you. So like talking about your alternate theories, you have to, each of those best interest factors in my mind is an alternate theory, and they all work together in conjunction with each other. And it's rare that just one is going to carry the day.
You have a question from one of my viewers, Andrew. Actually, he's a member. Thank you for your contribution, Andrew, and support. He is asking about perception and presentation. Would you say that part of your presentation of your case is how you are perceived by the court as to your credibility? I'll let you take that one over. I can go ahead.
Yeah, definitely. So in any case, judges are going to make decisions based on credibility, and they judge credibility based on a lot of things, your manner while testifying, your ability to remember things, whether or not you're evading answers or answering straight on, whether you're acting professional and respectful or whether you're getting angry and upset in the courtroom, whether you're badgering a witness, whether you're argumentative. So all of these things come into play. So I think that, yes, your perception or the judge's perception of you is very important. And part of what plays into that, if you're representing yourself, is your professionalism. And while you may not consider yourself a professional because you're not an attorney, you're representing yourself. So you have to act professional and you have to exhibit a high level of professionalism. And if you do that, and if you're prepared, I think a judge is probably going to think that you're more credible than if you acted the other way. I don't know if that answers the question.
I think it does, yeah. I mean, that's the root of credibility. Without it, your testimony is worthless, or it may as well be if your opponent's testimony is actually being believed. So, yeah, it's a huge thing. One of the these I guess are some small things, but one of the things that frustrates a lot of my viewers is their ex is caught in a lie, but then next hearing the judge forgets, and it's like it starts all over again. Like they get their credibility reset at the top. I don't know.
It's very frustrating. It happens a lot. I feel like the judges are so overburdened and they're overworked. They have so many cases and they do forget a lot. And I've had that happen to me where a judge will say at one hearing, well, this is kind of where I'm leaning. And then we go in and we're like, yeah, the judge is on her side. Then we go in and like the judge is totally flipped. And I'm like, what? And it's like the judge cannot remember what happened. Right. And so, yes, that's happened. But, I've had a couple of cases where a witness was caught in a lie or did something really bad, like just took the kids and moved to another state. And the judge never, ever forgot that. Like in this one particular case, it was like 10 years later and the judge still remembered. Wow. So, yeah, and it was the same judge. I mean, that was kind of miraculous that the same judge was on this case for such a long time.
Yeah, you brought up like 3 things I want to talk about. So those 2 things that you mentioned, lying, and in fact, even like falsifying financial disclosure forms, and then the other one, running off to another state, those were the 2 first cases that I wanted to cover in Nevada with our Nevada judges because they absolutely grind my gears. And they're both being broadcast live, the criminal proceedings, not the custody ones. And I think it's wonderful because people can see you're not supposed to do this and bad stuff's going to happen to you if you do. And now I can't even remember what the third thing that I wanted to mention was, but I guess let's, Andrew says, thank you for answering.
You're welcome, Andrew.
And I guess we could switch so you can talk about the power in truth. I'm going to go ahead and put the screen share back so they can see it.
Oh, cool.
So
Awesome.
Go into that.
Oh, okay. So, well, I am getting ready to launch this deck of affirmation cards, and it's called the Power in the Truth deck. And so I've been practicing family law for exactly 20 years. I started in 1999. I was a prosecutor for 3 years, and then combo defense attorney, family law attorney. And I see people who are going through divorce or separation, dealing with the same issues, struggling with the same issues day in and day out, both legal issues and both personal issues, and one day, this was a couple of years ago, I just thought, I wish I could have a message or give these messages to people, because I feel like they need to hear these messages that they're not alone, that they're not a failure, that it's okay to be angry, that there's no shame in going to therapy, that they can be their best own advocate. There's power in the truth. So I sat down and wrote out all the things that I could tell every person going through this process. That I wished I could tell everybody. And so what happened was I connected with an artist in the Ukraine, and she put pictures to these words. And we've developed this deck of cards called Power in the Truth for divorcing and separating individuals. And they're awesome cards. And there's 52 of them. And I know that when I've gone through my own difficult times in my life that I just wanted somebody to say, Wendy, it's going to be okay. And I'd look everywhere for messages. I'd look on billboards. I'd listen to the song on the radio and think, God, is there a message? I'd look at my fortune. Is a cashier at the store telling me something that I need to hear? I just wanted someone to tell me it's okay, that it's going to be okay. And that's what the cards are meant to do, is let anybody who's going through this know that they're going to be okay. There are going to be up days. There are going to be down days. But, stick by your truth and you're going to be fine. So that's what the deck is about. And they're going to be going on sale a couple weeks.
That's awesome. I actually haven't talked about this in a long time, but when I first came on YouTube, and also when I was first interviewed by Dwayne from Dad Surviving Divorce, people used to ask me what was my inspiration that led me to winning my child custody dispute. And I think my answer surprised a lot of people, but it's a cheesy answer, but it was a book series, and the book series had 10 rules of truth. They're actually
Mhm.
called Wizard's Rules, but they were based purely on truth. There was nothing magical about any of the rules. All 10 of them have to do with the truth and seeking the truth. And in some ways, they seem more about discerning deception and deceit and
Mm,
lies. And for me, it's almost become a religion. It's like
mhm.
what gets me through, I guess, my struggles and the conflict that I go through, because I continue to put myself into conflict. As I mentioned, I'm
Mhm.
now the administrator of our Nevada judges, and that's conflict galore. We just got
Sure.
into the Supreme Court. Did you hear?
No, I did. That's
Yeah, we'll be
awesome.
broadcasting live from the Supreme Court. Anyway, it's
Cool.
that's
That's
one of the
cool.
things that actually why I wanted to actually point this out, because I know you gave me a bunch of stuff to look through, but this is actually one of the ones that was on the top of my list, because
Oh,
the truth is what kept me going, and it wasn't
mhm,
necessarily always things are going to be all right just because. It For me, it was things are going to be all right because I'm going to figure out how to get to the bottom of this. And I'm
mhm,
sure that from I looked at some of these here, a lot of them are words of affirmation, but there's also
mhm,
some that are counterintuitive. Like I just saw a card come up that says fear is beautiful. Things that you
mhm.
wouldn't expect um, would be, I guess, inspirational. I don't know if you want to elaborate any
Yeah.
more on that, on some of the counterintuitive
Oh,
stuff.
yeah, for sure. Well, I think that, and I'm looking at the cards here right now as I'm speaking. I don't know if everybody can
They
see,
can.
if me or, oh, okay. So, there's this perception in our world. I think that fear is this ugly thing, that you should be afraid of fear. You should avoid it, that you should deny your fear. And, what I believe is that sometimes fear has important messages to deliver. Um, and you have to listen to your fear. You have to examine your fear and ask, is there something that I need to get from this fear, the fact that I'm afraid? And there may be something and there may not be. But the point is that you should not run away from your fear. It's kind of like, facing your demons, face the fear. And maybe sometimes your fear is really, the thing that you're afraid of is not as bad as you think it is. That's kind of the point. Fear is beautiful. You make your demons worse than they really are. And when you face it, you're like, oh, that wasn't so bad, you know?
It's true. It's totally true. There's so many counterintuitive things that if you don't pick them up, you're just going to stumble around, at least when it comes
Yeah.
to litigation and conflict. So, we got a
Yeah.
question from another member. Her name is Petra, and she is asking, oh, I even have some stuff to say on this, but you get to go first. What do you do when a judge is not enforcing their own court orders?
I That is really frustrating. What do I do when a judge is not enforcing their court orders? Um, well, that is a good question. And I don't know that I've had that situation come up that much, but I think that if orders are being violated and they're being violated repeatedly, I mean, I probably wouldn't file a motion for each separate violation. Like I'd wait till a few violations, pile up, for lack of a better phrase,
Hmm.
and then file a motion to enforce or petition for order to show cause uh, regarding contempt. And I would continue to do that to show a pattern. And if a judge continues to not enforce his or her own orders, then maybe I would look at doing something different. I'd probably talk to somebody like you, Alex, to see if there's something more that I could do.
Oh, it's a tricky topic here, because I've actually done the research on this, because I was worried, what if my judge doesn't do this? What am I going to do? And from what I've seen, the Supremes will intervene to vacate a contempt order, but I've never seen them intervene to force a judge to hold someone in contempt. And I'm not sure that there's anything you could do but keep on badgering the judge, aside from maybe a judicial discipline complaint.
Yeah.
But that's everything that you say. It works, because in my case, I tried once and he denied. I tried again and he denied. And then I tried the third time and he granted it. So
Mhm.
sometimes you just have to keep on telling him, this isn't stopping. I'm going to keep filing contempt motions.
Exactly. Well, and I think the thing is, I mean, I would think if I were a judge, I would want to be making the right decisions, because I would not want to get overturned on appeal, and if I'm seeing this person a person coming to me and making the same requests over and over again, I feel like if I were the judge, I would have to take a closer look at that. So maybe that, your strategy, Alex, does work, to keep on trying. And that's all you can do. You have to, I feel like sometimes it's hard because you have to tread lightly, because what you don't want to do is really make the judge angry, and then the judge takes it out on you even worse, which could happen.
Right. And they're not even appealable here. We have to challenge them by petition for writ of mandamus, which is
Oh wow.
discretionary. So then they don't even listen
Oh,
to it. More than 70% of writ petitions aren't even considered.
oh
Yeah,
wow.
so it's a situation here, I guess. Okay, but I have another side of that coin, and that
Yeah.
is sometimes, actually not even sometimes, a lot of times, the parties will stipulate to something, and it'll be quite frankly ridiculous to the judge, but the judge won't reject the stipulation because they're happy to close the case and move on. So they'll sign
Hmm.
the stipulation in order, and then the parties come back and someone violated it. I'll give you one example. I've seen a stipulation that the parties can't get a new relationship partner. So they can't like get a new boyfriend or girlfriend ever.
Hmm.
Not just
Whoa. Wow. Now I've never seen
I've seen
that.
a lot of funny stuff like that. Um,
Yeah.
and um, in those cases, what do you think? Because I can understand the judge doesn't want the conflict to keep going. So when they see the stip, they just approve it. And then when the
Yeah. I mean, I feel like I have had judges reject a few
yeah,
stipulations, and or you know not sign them and say, "You guys come in. I'm setting this court date because I want to explore what it is that you're trying to accomplish here." And so then, the judge would say, like, okay, you have this stipulation. These are the concerns that I have with this stipulation. What is your goal? And maybe we can craft something that accomplishes your goal, but that's, kind of more enforceable or legal,
yeah.
But I don't think I've ever had a situation where a judge kind of signed off on a stipulation. That sounds crazy to me, that neither party will ever have a partner again. I mean, that's
I've
crazy. I
seen it.
don't know that. Yeah, I don't think a judge here I would sign off on that. If they did, I believe they were probably not paying very close attention to what they were
That
signing.
happens a lot here. It's very rare for a judge to prepare their own order here. And
Oh, okay.
it's also quite common for them to not really read it. They may skim it really quickly, but you got like three comments here. It's starting to pick up. So
Oh.
Tenacious Warrior, no question, just a comment. She's frustrated
Mm.
that your part of the world didn't fall back this weekend, and she despises real daylight savings time.
That's
And
funny.
then we got Citrine says he's asking about accepting help and emotional support from trusted friends and family. And
Mhm.
he's mentioning how it made the difference in his case. Before you take this one, I do want to mention that if you could also comment on how maybe this can go too far and it can burden friends and family.
Mhm. Um, well, I think it's important to have a support network for sure, because going through a process like this is one of the most difficult things that you can go through in your life. And you have to have your warriors in place to support you. Um, Having said that, nobody can deal with your issues except for you. And nobody has the responsibility of dealing with this, is what I believe.
Mm-hmm.
Nobody has the responsibility for fixing your issues except for you. And I think that to a certain point, friends and family are going to be there for you. But at some point, it may become exhausting to them to hear about this day in and day out like a broken record. It doesn't mean the issues aren't important or that you're not important or they don't love you. But you're the only person that can fix it. And if it gets to be too much, there's people who can help you fix it. And not everybody, needs a counselor or therapist, but counselors and therapists are great people. And if I had time to have one help me just deal with life and difficult attorneys and judges, I would, because I think, counselors and therapists are a great thing. Um, I deal with a lot of the stuff that I deal with on my own. I read a lot of self-help books. I'm always trying to improve my mind and my body and my spirit. And that's the fantastic thing if you want to look at it that way about going through this. It is difficult, but it is making you a better person. It's making you a wiser person and a stronger person. And that is going to make you a better parent to your children. It's going to make you a better partner to a future partner if you choose to have one. So you have to look at this experience as a good thing. I mean, there's really gold in this experience, and it's hard to see it now, but someday you will see it and you'll feel it.
I have one more. I guess we just have 5 minutes left. I have one, and this is based on one of your that recent comment. And this one, I want to stress before I mention this to Wendy. I don't think this is bad, but I do notice it, and I wanted to talk about it because I think Wendy has more experience and maybe some insight on it. I notice, and again, I don't think it's bad, but I notice that a lot of times I get questions not from the litigant, but from the litigant's wife, husband slash girlfriend, boyfriend. And it's
Mhm.
like that individual is driving the case, like really knee deep in, okay, you're nodding. So I want to get your insight because I don't know what to think about that. And I help
Yeah,
them.
yeah. I had a case like this recently in the last few months, and it seemed that this situation that one of the parties' new partner was the one driving the litigation. It was very interesting to see um, the interaction at trial because the emails that I saw that were admitted as evidence were not consistent with the party who's testifying on the stand with that party's personality. And that's what I heard from my client. It's not consistent because it's coming from the new person, the
Mm-hmm.
new partner. Um, so it does happen. And, I feel like a new spouse or a new partner is important in terms of because they are, it's a blended family and this does impact the children. It impacts the children. So I think that the court needs to hear from that partner if possible. But really, the parent is the parent. The two parents are the parents. And, you know, the parent with a new partner who might have a strong personality really needs to look at him or herself and say, is this what's best for my children? Is this what I want? Is this good for the kids? Is this good for the family dynamic? And sometimes that's a hard thing to do, but um, it happens, Alex, and you can't control people,
And
that.
it
So,
doesn't even always seem negative. It does sometimes seem like that person's
yeah.
high conflict, but other times it feels like it's like the litigant is just not confrontational and doesn't want to fight. So it's like I said, that's why it's so hard to say it's always bad because I almost feel sad for them because they have no standing and no ability to turn the wheels of justice. They're just trying
Mhm.
to get answers from me, and I guess they're hoping to push that guy or girl into fighting, and it's really common on my channel.
It's it yeah, I think it does it happens a lot. Um It really happens a lot, and it's not always bad. Sometimes it is good, but really, um, one of the concepts we learned in law school and was really related to like, I think, tort law and negligence is, you have to take your victim. I'm not saying the person's a victim, but you have to take your person as they find them. If you get Mr. Eggshell Man and he's broken more easily than the guy down the street. I mean, you got Eggshell Man. So whoever you are as a person or whoever the parent is, I mean, you got to take them as you find them. And
Mhm.
they're not that strong of a personality and they try to minimize and avoid conflict. And that's kind of the way they are. And you're not going to change that person unless they want to change.
Yeah.
So
That's kind of what
it's,
Citrine just commented, sort of in line with what you just said, that the parent may be
yeah.
emotionally exhausted and, quote,
Hmm.
literally cannot do one more thing, unquote. So great
Hmm.
insight. And I got a question from Albert on appellate attorney fees. But before I answer your question, Albert, by the way, you're going to be the last question. I do have a question for Wendy. Um, at attorney fees at the litigation stage, not the appellate stage in Arizona in child custody matters, are they wide open like they are now as of 2015 in Nevada, or do they have to show that the other party is harassing or has brought something without reasonable grounds?
So in Arizona, there's two things the judge looks at. The judge looks at the reasonableness of the parties and their positions throughout the litigation, and the court also looks at whether or not there's a disparity in income.
Okay.
So those are two things that the judge looks at. I think in most cases, in many cases where there are attorneys involved, like most cases, judges say you each pay your own. But I've had a run of cases lately where somebody was abusing the discovery rules or disclosure rules, and the judge hammered that person, or if somebody was asking for relief that was just crazy, unreasonable, not in line with the law, and it just caused a lot of stress and drama and money to be spent, then a judge would order fees in that case too.
Okay, it's sounds a little bit more strict than Nevada now. Pre
Yeah.
2015, it sounds a little bit less strict than Nevada. In pre 2015, they had to show that the not only did you have to lose, but they had to show that you brought a claim without a reasonable ground, and or
Uh-huh.
that you were harassing, which was very difficult. But then in
Uh-huh.
2015, they switched and gave them a blank check and said the court can, at its discretion, award fees. There's nothing even in
Mm.
there about like the reasonableness of the or nothing like that at all. It's just really
Mm.
wild. Okay, Albert's question, and I'll take this and then we can sign off. But he's
Okay.
asking me about defending against an appeal and how to do research, and he's asking about attorney fees, going after appellate fees in Florida. Okay, so I can't tell you anything about Florida, Albert, but I can tell you that in Nevada, getting attorney fees in the appellate courts is extremely difficult. It's so difficult that I've seen shenanigans, like an attorney waiting until the case, the remitter issues, goes back to the lower court, and then trying to get their appellate fees in the lower court. And that has there's some funny decisions that come out when the Supreme Court catches wind of that. They've scolded the lower court like, how dare you award fees? That's up to us. They do not do it here unless you can show that the other person filed an appeal just to drive you insane with no basis at all whatsoever. It's less than
Mm.
1% chance of getting it. And research, I have a bunch of videos on it, but statutes, rules, and case law, that's how you win an appeal, and that's how you defend against an appeal. So, and of course, you get a few extra things in your favor, like if your opponent didn't raise an issue in the lower court, you can bring that up and have that waived. And they don't even if you don't bring that up, the Supremes will do it for you. They don't want to deal with
Yeah.
that kind of stuff if it's not been addressed. So,
I,
go ahead.
I want to tell you something, Alex, because the way you just went off, which I just love, but you know, uh, a friend of mine who I didn't even know knew that I had a YouTube channel. I saw her for lunch the other day, and she's like, "Yeah, I watched you and Alex the other day, and that guy's an encyclopedia, man. That guy's awesome." And I said, "Yeah, he is." So I just wanted to share that with you. It was funny. It was a surprise. One, I didn't know that she even knew I had the show, but two, that she just loved you.
Oh, that's good.
And I know now it's clear why people do, because you're so smart and you have such a passion for helping
Yeah,
people.
I want to help other people because I felt alone. Unlike other people, I didn't have friends or family to fall back on. And
Yeah.
the other thing is, a lot of people think that I was smart and that's why I won. But I started to figure out that if I didn't figure these rules out, I wasn't going to win. So I was
Mhm.
really forced into it because being
Mhm.
nice got me joint physical custody. I'm going to give my
Mhm.
judge some credit there. I was nice, I was deferential, I did what he told me to do, and I got joint physical custody. But at some point, things crossed the line, and I had to figure out how to get primary physical and later on terminate parental rights. And once you start to do stuff that's outside the norm, once you start to do weird things, the judges don't want to help you anymore. When you're
Mhm.
asking for things that they're
Mhm.
used to giving everyone all the time, it's like, oh, sure,
Mhm.
no problem. When you're asking to terminate the ex's parental rights, all of a sudden it's like, no. And so you have to force them to do it because they won't do it. And that's what I learned all this stuff because there was no other way to do it. I could have begged for
Mhm.
10 years and they wouldn't have done it. So
Yep.
it's
Yep.
that's what I had to do. I ended up transforming into this version of myself over 10 years, and it took a long time. So I'll let you get going. Thank you, Wendy, for coming on.
It's awesome. Well, thanks for having
Yeah.
me, and thanks to everybody for joining in.
Bye, guys.
Okay, bye.